Alright guys, it's been about a week since I talked about the bump stock ban, and I have some more updates for you. Now, before I start, I want you guys to know I'm genuinely just putting this news out here just to try to get it out there and just to help you guys know what's going on and so that we can stand up for our rights. Now, I will note, um, I've been following this website, bumpstockcase.com, and Firearms Policy Coalition has been putting like updates on here, and I've been following it the best I can. And I still have a couple questions, and there's a link here where it says members of the news media seeking statements or interviews should contact us here. And I've called that number twice, and I've been greeted by a receptionist both times, and she was very nice and took down all my information. And each time they asked me what media company I was with or what news organization I was with, I told them the obvious truth. I said, look, I'm just independent media. I'm a YouTuber with a small channel, and I've been actively trying to, keep people abreast of what's going on. And I've, just doing the best I can as a small YouTuber, so I'm not part of a big news organization. And she said, no problem, I'll have somebody call you back. I've tried again several days, and nobody from Firearms Policy Coalition has called me back. So just to let you guys know that apparently they don't have time, or they're not really too worried about answering any questions from a guy like me. They're more worried about mainstream media, and it's a little disappointing, but whatever. So if I get something a little bit wrong here, guys, I'm sorry. Just keep in mind, I'm by myself. This channel is just something I do in my spare time for fun and to help, the Second Amendment, and to try to spread the word for us to keep our rights. But nobody's helping me with this, so I'm trying my best to get you guys the information. Okay, with that said, basically, about a week and a half ago, I let you guys know that, look, the DC Circuit Court has now said that, look, bump stock ban is going to go into effect. We're not going to overturn it. We're not going to create an injunction, which would therefore stop the law from going into effect. But we are going to have a stay. That's what I said on the last video. And this stay is not only going to include Gettys, but after a clarification on the stay that Firearms Policy Coalition have requested, the new clarification had stated, look, any bona fide member of Firearms Policy Coalition or Foundation is considered an appellant. So, as reported, and it's still on their timeline here, you guys can look for yourself, bumpstockcase.com, the members of Firearms Policy Foundation, they're going to be considered to be part of that stay. So that's where we were at. And I said then, I don't know how long this stay is going to last, because this stay by the federal court is only good until a higher court overrules it. So there's a little background to catch you guys back up to speed, refresh your memory, So here's where we're at now. So Monday, the DC Circuit Court of Appeals heard the appeal from Firearms Policy Foundation on behalf of Gettys and all of the other plaintiffs, including the members of Firearms Policy Foundation, right? And they were trying to appeal the lower court's decision that they wouldn't put an injunction, just stopping the law outright. Well, I knew about this Monday, but I was hoping Firearms Policy Foundation would call me back and clarify a couple questions, which they didn't, so that's why there's the delay in me getting back to you guys. Please forgive me. Again, I'm just trying my best, guys. I try my hardest to not just be the first guy to break the news, but I want to put out accurate information. So what happened this past Monday, April 1st, is they went into the Circuit Court of Appeals for the District of Columbia, and right off the bat, not very good news. They sided with the DC court that had originally made the decision, and they said, nope, we agree. We're not actually going to overturn the lower court's decision. We're not going to create an injunction, and we're not going to create a stay for the whole country. We're just going to basically reaffirm what the lower court already said. The bump stock ban can stay, and we are not going to further the stay to the whole general public. We're going to basically keep it how it is. And I printed off a copy from the United States Court of Appeals. I'll read this very briefly, guys, but this is basically the legal document that applies to this decision on last Monday, April 1st. And it says, judgment. These causes came to be heard on the record on appeal from the United States District Court for the District of Columbia and were argued by counsel. So that's the one that I was talking about a week ago, right? The District Court of DC. On consideration thereof, it is ordered and adjudged that the district court's denial of the preliminary injunction appealed from in these causes be affirmed. And accordance with the opinion of the court filed herein this date, it is further ordered that the administrative stay of the effective date of the bump stock rule 83 Fed Reg 66514 of December 26, 2018, that was entered on the court's own motion on March 23, 2019, will remain in effect for 48 hours from the time of the issuance of the opinion, in this case, to allow plaintiffs, if they wish, to seek a stay from the Supreme Court of the United States. Should plaintiffs do so, the administrative stay will remain in effect pending disposition of the stay application. Plaintiffs are directed to notify the court promptly should an application for a stay be filed. It is further ordered that Cordura's plaintiffs' appellants notice a voluntary dismissal of Whitaker-based claim number 19-5044, construed by the court as a motion for voluntary dismissal, be denied. And then it concludes by saying, the court is directed to withhold issuance of the mandate pending resolution of any stay application filed to the Supreme Court. Plaintiffs are directed to notify the court promptly of the disposition of a stay application. If plaintiffs do not seek a stay from the Supreme Court, the clerk is directed to issue the mandate 40 hours after the opinion in these consolidated cases issues. So, from what I understand, in plain English, what that means is the stay that was granted by the district court, the one I announced a week and a half ago, they're saying, look, we're going to end that stay. But the little silver lining is we're going to give 48 hours for the plaintiffs, which would be Getty's and all of the other associated members, right, that are bona fide members of Firearms Policy Foundation. There's a couple other organizations involved in Florida and such, right? So basically, that was the first. Now, they had until the 3rd to file yet another appeal to the Supreme Court, and then that would keep the stay alive for everybody, right? And that is actually what they've now done. And by looking at bumpstockcase.com, I can see here where it says on 4/3/19 Update 1, we have filed a second stay application with Chief Justice Roberts. And then another update, number 2, on 4/3, it says link to Supreme Court docket for application stay. Now, so within the 48 hours, it looks like, the lawyers representing this case, you know, for the plaintiffs, have now filed another appeal to the Supreme Court. So, as we speak, since I have not heard anything from the Supreme Court, the preliminary stay, not to be confused with injunction, an injunction would just stop the ban in its tracks. The ban did go through, just so you guys know already. The ban's in effect. But there's some people, meaning Getty's and the other plaintiffs, are granted a stay right now, meaning it's not, the enforcement's not going to affect those that are bona fide members of the Firearms Policy Foundation, Getty's, et al. Is how they word it. So that was going to expire on the 3rd, but it looks like in the nick of time on the 3rd, from what I understand, they filed timely enough where now the stay is still continuing, because that's what it says here in the recent ruling on the 1st by the Circuit Court of Appeals, that look, we're going to confirm what the lower court said, but yes, we'll let the plaintiffs still have a stay of enforcement for 2 more days, or unless they obviously go to the Supreme Court, which they've done. So it's my impression, again, not giving you guys legal advice, I'm not a lawyer in full disclosure, but from the plain reading of all this, it looks like, hey, look, right now the stay is still in effect for those members that I was talking about a week and a half ago. But I would note, the Circuit Court of Appeals did hear this pretty quickly, and they pretty quickly agreed with the lower court. So it looks like they're trying to hurry up and get this all over with and not let these temporary stays drag on for years like we had hoped. You know, a lot of people had said, look, Trump's playing a 3D chess where he knows the courts are going to tie this up for years and they're not really going to get banned, and then the courts are going to overturn it. It's not looking that way, guys. They're very, very swiftly going up the ranks of the courts through the different circuits of appeals, Supreme Court, and they're deciding quickly, and like as quick as I've ever even seen almost in the federal court system. They just keep shooting the plaintiffs down one after another and saying that this bump stock ban can stand, we're not going to grant an injunction. It's just not looking good. But I do believe as we speak, since it's now been further appealed to the Supreme Court, I would note for a second time, just with the Getty's case and Firearms Policy Coalition's case, the second time in a row, to Chief Justice Roberts. Now, I would note, he shot down the appeal last week when they appealed the district court's decision. Will he shoot it down again this time? I don't know. This stuff's really complicated. maybe there's technicalities in this appeal that'll make him look at it differently than the 1 week before. But let's just say a week ago, on the same general subject matter, Roberts shot down the appeal. So he could shoot down this appeal today or tomorrow. And then I think when that happens, we would have 48 hours. When I say we, I just mean the collective community that may own bump stocks or may not, because I don't know if I own one or not. It's not relevant. I'm just saying, if we had a bump stock, then all of a sudden we'd have 48 hours to then dispose of it, turn it in, whatever, after Roberts makes his next decision. I would note he also ruled against an injunction from the GOA's lawsuit that went to the Michigan Western District Court and then made its way to the 6th Circuit. And after both of those courts shot us all down, then the GOA's lawsuit went to Roberts in the Supreme Court. And guess what? They shot that down too. So like literally everything's getting shot down, guys, no matter how high it goes right now, with the exception of there is still a stay in effect for bona fide members of Firearms Policy Foundation, Gettys, and a few other people, etc., right? So that's kind of where we're at. If I got something wrong, guys, I'm sorry. I've tried to get clarification on a couple little details from Firearms Policy Foundation. They won't call me back. That's fine. I'm not important enough to get a phone call. But this topic's still important enough that I still want to get this out to the viewers and give you guys an update, letting you know that, yes, since I talked to you last, we've had the Supreme Court deny a second stay application. We've had Roberts specifically deny a stay application. We've had the D.C. Circuit now rule 2-1 against Gettys, upholding the D.C. district. They have said they're going to keep the stay in place for 48 hours as long as it's appealed to the Supreme Court, which has happened from what I see here. So that's kind of where we're at. There's still a stay, I believe. Not giving you guys legal advice, but I believe there's still a stay of the law taking effect for these bona fide members of Firearms Policy Foundation. I'm going to reference a real quick article here that I'm looking at. This is from the ABA Journal, and they're just reminding us here. It says Chief Justice John G. Roberts Jr. in the U.S. Supreme Court refused to intervene in 2 cases last week, one from Michigan and the other from Washington, D.C., the New York Times had reported. And then it says, on Monday, the U.S. Court of Appeals for the District of Columbia Circuit refused to block the ban in the D.C. case, while keeping a stay temporarily in place that applied only to the plaintiffs. So that's one of my sources for saying that not only me actually reading the docket, but it's being reported by newspapers that yes, the temporary stay is still in place only to the plaintiffs. Now, how temporary is this? Well, unfortunately, it seems a lot more temporary than what we would have hoped. We would have hoped it would have been years before it made its way through these courts. Nope. It's already right now, as of yesterday, the 3rd, it's been sent to the Supreme Court. Now, I would note last week, Chief Justice Roberts issued his denial within like 1 or 2 days. So I'm hoping this isn't the case. Gosh, I hope it isn't. But it could be like tomorrow or something, or the next day, that he denies it. And then I believe it's all over. Maybe 48 hours after that at the most. But before everybody has to get rid of their bump stocks to follow the federal law. So that's where I believe we're at. I'm citing this Court of Appeals docket. I'm citing, published media from the ABA Journal. Okay, took a little quote from them. And I will say real quick here, let me touch on this for a minute, guys. What happened the other day? Now, this was Monday, April 1st. And I'm looking at an article here, and this is from thecourthousenews.com. And they say basically, the D.C. Circuit on Monday upheld the Trump administration's ban on rapid-fire gun attachments known as bump stocks. And I'm looking here, there's a 59-page majority opinion, and a quote from that says, "We determined the statutory definition of machine gun is ambiguous, and the Bureau's interpretation is reasonable." That was in the 59-page majority opinion. So they're still clinging to that whole look. The definition of machine gun is ambiguous. Now, you guys take it upon yourself. Go look for it. It's very, very pointed, actually. I don't see any ambiguity at all in the definition of a machine gun. It's pretty well laid out, and a lot of people have done a good job explaining exactly how a bump stock works, and I don't think any reasonable person could possibly conclude that a machine gun functions in the same manner as a bump stock, but that's what they're saying. And unfortunately, even though I remember Adam Kraut and John Patton, Gun Collective, they took the time to do some very high quality slow motion videos that literally, like with photographic and video evidence, proved that they work differently. And those were actually submitted as evidence from what I understand, and they don't care. Even though it's completely unreasonable, unfortunately, the way our country's set up is if it's a circuit court of appeals that feels away, it doesn't really matter what all of us think. It's just the way it works, right? And it sucks to say this, but hey, it is what it is. They define what reasonable is. They define what ambiguous is. And if you guys are just seeing my channel for the first time, go back to my video a few days ago, 1984. How many fingers am I holding up? I think we're back to that again, aren't we, guys? And for those of you that saw the video, I think you know what I mean. They're being ambiguous about what the word ambiguous means. Like, literally, that's what's going on here, if you want my opinion. Now, it does say here again in this article, the court said it would extend a temporary exception to the ban for the plaintiffs by 2 days to allow them to seek a stay from the U.S. Supreme Court. That's what I was trying to cover earlier, guys. And then it says Joshua Prent, a civil rights defense firm attorney for plaintiffs Damian Geddes, Shane Roden, the Firearms Policy Foundation, the Madison Society Foundation, and Florida Carry Inc., said his clients intend to do just that. So that's what I meant by the collective plaintiffs earlier, right? Policy Foundation and its members and these other organizations. And then to quote Prince, he says, "We are in the process of reviewing the decision. We'll be seeking a stay from the Supreme Court within the time contemplated by the D.C. Circuit," Prince said in an email Monday. So, and it looks like now by looking at bump.case.com that yes, they have actually applied to the Chief Justice. Now, about the ruling itself, a couple more tidbits. It says the split panel, which ruled 2-1, reached its conclusion by applying Chevron deference. And I mentioned Chevron deference before. That's the killer here, guys. This stupid Chevron deference. And this Chevron deference basically goes against what many people still say, that Congress makes laws. Only Congress can make laws. Yeah, I know, it says that in the Constitution, doesn't it? But the truth is, yeah, kind of, sort of, maybe, and sometimes almost not at all, because of this Chevron deference, which requires federal courts to defer to agency interpretations of ambiguous laws Congress left to federal agencies to administer. The name comes from a landmark Supreme Court case, Chevron USA Inc. versus Natural Resources Defense Council Inc. So, look, guys, I'm not trying to stir up the pot here, but here's the thing. A lot of people have been saying in the comments and different things that, hey, look, only Congress makes law. This is unconstitutional, blah, blah, blah. Yeah, I agree with you guys. I read the Constitution exactly the way it's written, too. That's how I read it. That's what I want it to mean. And it sickens me what's happened here. But here's the facts. Landmark Supreme Court case that sets precedents. It literally directs all of the lower courts, again, you know, to apply this Chevron deference, which requires federal courts to defer to agency interpretation of ambiguous laws Congress left to federal agencies to administer. Unfortunately, they've allowed Congress, who makes laws, they made a law that said, now look, agencies are allowed to interpret the laws we wrote. So they actually do have some teeth, unfortunately. And the ATF is actually kind of sort of allowed to create law almost, if you will, by fiat. Now, they might not call it a law. They call it an interpretation. But look, these regulations that are based on interpretations, they carry the same prison sentences. They have all the same force and teeth of what a law does. So if you want to argue the semantics of whether this is law or not, that's fine. But make sure you're just arguing it in the abstract alone. And it is an interesting argument in the abstract. But in real life, these regulations and these interpretations, they become de facto laws because they're allowed to use the full strong arm of the government to come. People with guns can come, and they can charge you with these crimes, and they can take your property because Congress has allowed them to do this, and it's been further cemented in by this Chevron case that says, yeah, they are supposed to go by the interpretation of an ambiguous law. Well, what's ambiguous and what's not? I don't think there's anything ambiguous about the definition of a machine gun. And I'm sure most of you guys agree. But the fact is, people in a very high court, the Circuit Court of Appeals of D.C., which is known to be the second highest court of the land, that's considered the federal appeals court with the most clout, right underneath the Supreme Court. They just decided it's ambiguous, guys. So there you go. A few people have a stay right now. Other than that, the ATF was allowed to basically change the law, and you could argue further, kind of create their own little new law within the National Firearms Act, as bona fide by the Supreme Court itself with the Chevron case. So look up the Chevron case, guys. It's pretty interesting. So it basically says, furthermore, here, the bump stock rule sets forth a permissible interpretation of the statute's ambiguous definition of machine gun. It therefore merits our deference, the unsigned majority opinion states. And then it says, out of the 3-judge panel that heard this case, 2 Barack Obama appointees, U.S. Circuit Judge Patricia Millett and Sri Srinivasan, affirmed the district court's opinion. So those are the 2 Obama appointees that rule against us having the bump stock. Now there was a dissent. U.S. Circuit Judge Karen Henderson, a George H.W. Bush appointee, partially dissented. In her view, the bump stock ban contradicts the statutory definition of a machine gun. Henderson said she would only apply Chevron deference if Congress had expressly delegated its lawmaking responsibility. And then, in quotes, it says, the Congress has made no such clear statement, she wrote in her dissent. And then, quote, instead, the ATF relies solely on its general rulemaking policy power and statutory ambiguity. So she's calling out the fact that the ATF, yes, they were given some power for general rulemaking, but now they're going way more specific and way more pointed into their rulemaking than what the Congress ever intended them to. And I agree with her. Let me know what you guys think, but I think the way she's wording it is how I believe it. Now, if I could really have my way, I don't think ATF, considering how they work for the executive branch, and they're a law enforcement agency, and we're supposed to have 3 co-equal branches of government, I don't think the ATF should be allowed to interpret any laws, if you ask me. I think interpretation of the law should probably be the judiciary branch, enforcement should be the executive branch, and the lawmaking should be the legislative branch. So don't for 1 minute, guys, think that I'm arguing for any of this. I'm just telling you guys the sad reality of where we're actually really at right now. Where, yes, the ATF does act as the executive branch by their very nature, because it's a proven fact they're in the executive branch. People have been actually arguing this lately, guys, but it works literally something like this. President Trump appoints a cabinet. They serve at the pleasure and will of the president. President Trump called for a bump stock ban, directed his attorney general, who's a cabinet appointee in the executive branch, who then is the boss of the head of the ATF, right? So attorney general, ahead of the whole Department of Justice, then the ATF and others fall below him. So they're part of the executive branch. Don't let anyone tell you different. And I've been watching videos lately where people are trying to tell you different. So they're executive because that's literally what they are. But yes, they are also acting as if they're part of the judiciary branch, the ATF is now. They're judging what a law was supposed to mean. I don't think that's their job. They're also acting as a legislative branch, writing rules. They don't call them laws, but since the rules hold the teeth of laws, yeah, they are writing laws. And I believe all of it's unconstitutional, and we need to drain the swamp, and it needs to stop. But these are just the facts, guys. It's happening. Although I've tried to portray to you guys that I don't agree with any of it. And then in the end here, Henderson goes on to say, Henderson said the rule misconstrues the definition of, quote, automatically, which in her view would exclude a machine gun with a bump stock, which requires a shooter to maintain backwards pressure on the trigger. She actually brought up something really interesting. If you guys think about what that actually means, that was kind of cool. Now, it doesn't mean much because she was in the dissenting, right? But still, though, a federal judge, she actually had the foresight to really look into this, and she makes the argument that if you had a real machine gun, a no questions asked machine gun where you just hold down the trigger, brrr, empties the magazine out. We know that's a machine gun. She says that if you put a bump stock on an actual machine gun, it would actually not even be a machine gun anymore. So the bump stock is so much not a machine gun, you could attach it to a real machine gun and make it where the machine gun isn't even a machine gun anymore. And if you guys think about how a bump stock works, I think she's actually right. So kind of interesting, isn't it? How she put that spin on it. Well, one person had our back, 2 people didn't. 2's greater than 1. We just lost in the Circuit Court of Appeals. It's going to Roberts. He's denied the last 2 very swiftly. Will he deny this one? Gosh, I hope not, but I'm not going to bet otherwise. So, as far as I understand, citing my sources of Firearms Policy Coalition, the Courthouse News, I'm also citing ABA Journal. I believe all of the original plaintiffs, Firearms Policy Foundation members, etc., right now still have a stay, pending what Judge Roberts says. I believe after that, there'll still be a 48-hour, turn-in period, if you will. But I'm not going to say that for sure because, again, Firearms Policy Foundation has not been able to call me back to clarify. But I just couldn't let this video go on any longer, guys, because then I'd be just totally abandoning this topic. And this topic's been important to me for a long time, so I'm putting it out there. I know you guys are still going to have a few questions that I have too. I can't get them answered right now, but I'm trying. And it's a little bit of a long video, but I am covering like in a week and a half's worth of news that I was trying to put off to get some answers clarified. So hopefully you guys understand what happened and you're not too disappointed with me, because it's not that I was dragging my feet, guys. I just really, really want to put out accurate information to you. And it took me a lot more research than I wanted to, but yep, I wasn't able to get it from the actual, plaintiffs themselves. So I had to do a lot of research, and I think I pretty much portrayed this to you guys, and hopefully you found the information helpful. So, all right, anything else you guys got to say, leave it in the comments. I'll probably be talking about this again, and let's really, really hope the next time I come on, it's because on different types of merits, now Roberts is going to grant a stay, and the Supreme Court's going to really look at this. Let's hope that's what's going to happen. But either way, for better or worse, I'll be back with you guys soon on this topic. And in the meantime, I'll do videos on other stuff. And don't forget, guys, Friday, I'm going to be doing live streams on a regular basis again. So if you guys have bored or think it'll be fun, join me tomorrow night on my channel for a live stream. All right, guys, thanks for watching, and have a good one.